if you just keep posting content about yourself and what you do and your expertise, your interests, things like that, people will they may not hire you the first day they see anything, but they might follow you then. And then they, 6 months later will hire you when something comes up or after they've consumed enough content, something like that. And so if you just keep providing value, people will throw money at you, eventually. You don't have to go out there and pitch and do all of that.
Right, so listen to that again. Keep providing value, people will throw money at you.
Welcome to the Love Your Brand podcast. If you're looking for real conversations with real people, you're the right place. Let's go!
Let's go, let's go, let's go. Welcome to the Love Your Brand show. Today, please welcome Miss Ana Junega. She's an award-winning intellectual property attorney and the founder of Ana Law. She does everything, guys. And I just welcome you to the show, Ana, and just want to give you the floor right off the bat. How are you doing today?
Good to have you, Ana.
I'm doing so great, and I'm super excited to be here. And thank you so much for the kind introduction. And yes, I do everything in IP. So I do patents, trademarks, and copyrights, some business items, business law items. And I love it. And I love working with business owners. So I'm really excited to get into today's episode.
That's awesome. You bring something that we have not had on yet. So we're excited to chat with you today. So how did you get into this anyway? Is this something, from childhood you wanted to do?
I don't know when the point was that I decided to get into IP, but I think it was sometime prior to law school. I was always really interested in science, but I was always a really good writer. So I knew I was going, to be a lawyer, but I think I really didn't even know what IP was in law school, even though I focused on it. I worked at the USPTO. I did a lot of things, but I didn't really know that I was going to love IP as much until I started working at my first firm. And then somehow it just all worked out. I never had a job before, or a real job before. And so it was my first experience really working. And, I just was really lucked out because I didn't have to switch. I just was really good at it and I really loved it.
So you worked at previous firms and now you have your own firm. Is that correct?
Yes. So I worked at other law firms before I started my own firm for several years. And then, I just saw that, there was a gap in the market for certain types of legal services being delivered to certain types of clientele who really needed them. So that's why I started my own firm.
Awesome. And you're pretty active on social media. I don't want to stereotype lawyers, but, when you think of lawyers, most people can think of this category and just kind of, and I mean, without having to describe it, it's like you think of it, but you kind of seem a little out of the box. And so when you go on your social media, you have, it's very personal, it's very engaging, it's very real. I mean, you're a smiling face versus, sometimes when we think of lawyers, it's like, oh man, am I getting sued? How much money am I going to pay? Kind of a thing. But your social media content portrays something different. Was that on purpose or, to kind of contrast what's out there so that you really set apart and are different? Or is that just kind of how you are and just who you are?
I definitely think it's just who I am. But I also think, I'm in a more unique field of law than a lot of other fields of law. People are coming to me a lot because something really amazing is happening. They're launching a brand, they're starting a business. It's not necessarily that, I've murdered someone. Can you help me not go to jail? It's not that situation. So people are a lot happier, I think, dealing with their business and IP attorneys versus some of their other lawyers. Of course, there's still bad situations. People still get sued. We have to sue people all the time. But, in general, I think it's a little bit more of a pleasant field. So there's that component. But I'm just, I really like what I do. I really love business. I definitely consider myself more of a business person over a lawyer. And that, I think, comes across. So those are what I focus on. I don't really focus a lot on, actually focus very little on law because my law content doesn't do that well. I focus more on business and personal content. And then I sprinkle in the law content when it's very useful when I have specific questions from clients or prospects, and I'll just make a video about it because I know I'll get it again and I can just send people the video. So that's really where I make those more detailed law videos. But otherwise, I really stick more general with my content.
That's really good. That I think you just said it perfectly, because when you come across a page, it looks more like business. If you didn't have a bio and really read what you did, you would just think it's kind of business advice. And, when you were talking about being in the law firm, you said with IP, I didn't even really know what it was. And I think that's where most businesses are today. They don't really understand IP. When they think of, I need a lawyer, it's for these things like I'm getting sued, or I need legal advice or something like that. But they never understand that IP is a category that is really important for the branding of the business, the trademarking, the copywriting, and all that. So like, what would you say to a business that's like, all right, what is IP? How does it apply to my business? What do I need?
Yeah, well, I'll start by saying this, that if all businesses were actually just registering everything, doing their due diligence, filing your IP registration, setting up your business correctly with proper contracts, filings, all of that is kind of like insurance policy for a business. And if all businesses were doing that, law firms, including my own, we would not be in business, because it's not that profitable to just help someone do something right. It's much more profitable when things go wrong and people are getting sued or they need to sue other people. So there's, the caveat to, people not wanting to spend money on doing all of this. It's a lot less expensive to do things correctly. And I don't really have incentive to say that. It doesn't help me. But in general, people skip over a lot of these things, maybe because they don't know, or because they don't have the funds for it, or they don't want to come up with the funds for it. But it's really important, because the smaller of a business you are, skipping out on your IP and business setup and registrations will actually cost you a lot more and be a lot more painful than if you were a large business with deep pockets that you can handle, that you have cushion for that blow. But small businesses can go under if something goes wrong. So putting in the time and, investing into properly setting up your business and protecting your IP is just, like I said, I consider it an insurance policy for businesses.
So thank you. Thank you, Anna. It's, I first just want to say congratulations. Your personal brand is on point. Yes. I really enjoy it. I really enjoy your social media. It's edgy. Right? It's unpredictable. And I think that's what draws people to it with the subject matter. So kudos. I'm constantly talking about your personal brand and how it relates to your business or multiple businesses. So I really enjoy that aspect of it. And I know you're killing it even on LinkedIn. I know at one point you were helping people, right? With their social media on LinkedIn?
Yeah, I do like some consulting for other lawyers and things on LinkedIn. So that's been really great. I really think LinkedIn is the most important platform right now for most people. Yeah. And I don't know why more people, don't understand it, but I've gotten 6-figure deals on LinkedIn. I definitely get more traffic from other short form video content, Instagram, TikTok, YouTube Shorts, but in LinkedIn is where you're going to be able to stand out, because no one really posts on LinkedIn, or the people posting on LinkedIn are just the people showing you how to do LinkedIn. But there's not really a ton of normal professionals or normal service providers posting on LinkedIn. So I think it's just really easy to stand out. And that's where everyone is. Like, even if they're not commenting or engaging with you, they're watching you. So that's where, you get the big deals done.
So for you personally, where would you say is your biggest source of leads that come in? Is it social media? And if it's social media, which platform specifically? How are people finding you?
Yeah, so I'm now a few years into my business. So definitely my most referral source my most leads are from referrals from prior clients, other attorneys. But if you take out referrals and just organic new clients, because I don't do any paid advertisement, I would say the most number of leads is definitely coming from Instagram, but those cases are smaller case value than the cases I'm getting on LinkedIn. So monetarily wise, LinkedIn by like a 10-fold factor. Absolutely. And I have a fraction of the followers on LinkedIn than I do on other platforms.
Yeah. So I mean, it's more quality, quality versus quantity. I would rather have 10 very engaged, qualified leads as opposed to a list of 1,000 that are just mediocre and, not really a qualified lead. I see one post you did recently I saw on Instagram was talking about haters. And you had mentioned, I want to hear you comment on it. You had said that, you had some haters kind of posting, which we all have haters. Honestly, I think it's a compliment when somebody hates on us. We're doing something right. But you had some haters that commented on some stuff and then they ended up being clients. Like, can you comment on that? What that was all about?
Yeah, I think it's so interesting that happens because, I mean, there's always haters. I don't listen to them. I don't even read comments. I don't engage anymore because I would post a random photo of like an ice cream cone and there's like 3 hate DMs. So people just have a lot of time. I've gotten hate DMs about the moon. Like I remember I posted a picture of the moon. And so, people are they always have something to say. So you just can't really listen to them. But, sometimes they're right if they tell you, they used to tell me, you look bad, do this, like your audio's bad, like wear headphones. So some stuff is better, like you can improve things. But for the most part, people shouldn't listen to haters. And then, whatever reason, there's a lot of people who will follow you and they'll still leave hate comments or send you mean DMs, but they won't unfollow you. And so then if you just keep posting content, eventually something's going to come up in their life and they're going to need some, trademark or patent or business work done. And then they hire me. But I just find it so interesting that happens because you would just think that, they wouldn't want to hire you. But if you just keep making yourself known and everybody knows what you do, then that's just how you grow your network. Whether or not someone liked you at the beginning or didn't like you, and maybe they still don't like me for certain things, but they're fine with me doing their IP work.
That's really good. Sorry, Jason. Like a few things makes me think of, my dad told me a long time ago, he said, never burn bridges. And, your approach there makes me think of that. We can take offense. You're right. I mean, there are people, I think their whole day, they're just unhappy in life. All they do is get on social media and who can I hate on today? Who can I just fault today? Who can I have this and that? But don't burn bridges. Number 2 is just show up consistently providing value. If you go on your platforms, you can look at everything. It's just value, because so often in business, we want to go in and just make the sale, but we never nurtured people and we never gave value and content over and over again. So even if these people want to approach you and like, hey, I'm just going to, complain about everything she does, but dang it, she keeps putting valuable information. It's actually helping me. You just have to consistently show up. So it speaks volumes about your authenticity, your integrity, your character, and who you are. Because with any relationship, we talk about this often, there's 3 stages of any kind of relationship. And that first one is curiosity. So you put something out for the first time, somebody comes across your brand and it just has to pique their interest. Like, okay, I'm curious. I want to learn more. And then the second stage of the relationship is enlightenment, to where you're pushing out content that really starts changing their life. It's like, okay, if I take the principles, I take the content of what Anna is teaching me, this can help me as a person, or this can help me in my business. And then at that point, they get to a place of trust, to where maybe these haters finally got to, okay, I trust Anna, and so I'm going to move forward with her. So it's just so interesting that you didn't just have leads come in that you converted to clients. You actually had haters that came in that you converted to clients, which is a lot more rare. So kudos to you for how you showed up.
No, I really think it is that don't ever burn a bridge. So whenever I get a hate comment, I don't delete, I don't comment or really engage with it, but I don't delete it. Because you just never know. You never know when someone's going to need you. And then another thing is I'm just such a big proponent of providing value and information and just showcasing things about your personality or your life and letting people sell your services like to themselves kind of thing. So I never pitch, I never go on there and say, oh, like you should buy this from me. Because there's also a lot of advertising regulations around lawyers. So I don't know if I'm allowed to do that. I don't understand the rules around advertising that much for lawyers, the ethics rules, but I just put out information. So everything I do is clean. Like I can say, it's all been education, entertainment. And then no one's going to ever say I propositioned people, online. And then the thing is, when I started to do that, though, really quickly, I realized that if you just keep posting content about yourself and what you do and your, expertise, your interests, things like that, people will they may not hire you the first day they see anything, they usually don't anyway. but they might follow you then. And then they, 6 months later will hire you when something comes up or after they've consumed enough content or, something like that. So every client that comes to me from social media has told me, not everyone, but the vast majority of them that I ask for that they mentioned, they say they've watched all my videos. They've been following me for years. Like they all say that. So I know that it's never that someone comes across one video or one post and they just hire you. Just like in the regular sales for other businesses, they usually takes multiple times that they have to see you before they'll hire you. But it's the same thing with content. And so if you just keep providing value, people will throw money at you, eventually. You don't have to go out there and pitch and do all that.
Absolutely. So listen to that again. Keep providing value. People will throw money at you. That's a mic drop right there.
And I think that's what you do. She keeps providing value. You said it, Jay Hill, is being authentic with your personal brand. So, how you are now is how you are on social media. So be yourself. I think a lot of companies, a lot of businesses, a lot of brands try to be someone else, try to follow the trend, try to follow whatever is trending. But yeah, just be yourself, be different, right? And give value. And I think that's where you've been excelling at.
Yeah, definitely. I just stay in my own lane. I don't know what's going on with other people or what they're saying. And you just keep doing your thing and,
that's it.
Keep talking about your business. People get mad when you talk about your own business, right? That's another crazy thing. But, I'm not out there promoting my outfits and lip gloss and things that, influencers do. Everyone gets hate for doing whatever they're doing on social media. But if you just keep providing value, stay consistent, stay authentic, then it'll all be fine. Even if people get mad at you for some things you may post or do, it all evens itself out. And as long as you continue to improve, I think you'll always do well.
Sure. But that's a good point to where, we're attracted to the brands and the people that align with our core values, that align with our beliefs. And so, I could search online for IP lawyers and I could find a list of 10 of them that I want to follow and get my information from. And y'all might provide the same information, but you communicate in a different way. You're personable, you're fun, you're whatever it is that's part of your personal brand. Because as Jason said, your personal brand is spot on. And our personal brand and our business brand, they're synonymous with one another. We always say that. And so there has to be that authenticity to where when somebody thinks of Anna Law, they think of Anna. When somebody thinks of Anna, they think of Anna Law. And so they're just meshed together as one, even though they're two separate entities with a personal brand and a business brand. So I think you do a really good job of that. And this happens every time. I totally lost my train of thought where I was going with that. But
so another thing I feel that really, and this will kind of bring it back to some of our questions, is I also have a lot of business experience that, there's a lot of business coaches out there on social media, but there's not a ton of lawyers that have as much business experience as me. Even IP lawyers, very few have that much business experience. Experience with logistics, supply chain, the level of experience that I have. And
so that's where I was going to go. I'm sorry to interrupt. So where did you get all that experience?
Because I have been in business since I was a child. I've been working with seeing my parents, working with them, my cousins, literally every single person in my family has a multi-million-dollar business. And wow. I saw them when they started, like when that LLC paperwork was filed, right? When I was a kid. So I have grown up in business.
That's incredible.
And all different types of businesses, online services, in-person services, brick and mortar, professional services, export, import, logistics. So I'm so deeply immersed in the business world just for my own personal experience that, and, I've also started and failed multiple businesses throughout my, especially early 20s. So I've gone through a lot of things that people go through when they start businesses. And that's why I say I'm a business person before a lawyer, because at the end of the day, I can write you a 20-page memo all about, something about trade secrets, patents, copyrights, whatever it is. And I'll think, I'm giving you guys a lot of great thoughts, but it's not really going to mean anything for you because you just want to know how something is going to affect your business. What's the best options to move forward? What are the different costs of the different options? Business owners need specific type of information to make informed and pragmatic decisions. And because I have so much business expertise, I think I can relate that information better to them than many IP lawyers out there.
That's good. You mentioned you mentioned that you failed in business, and I think failure is such a great tool for us, and failure is a great teacher if we allow it to. And that is one of those things that can connect people, because I think so often in business, we see brands that are so successful and it almost seems like so unattainable because, well, I'm not there. That person is here, but I'm only here. But failure can unite us. It's like, oh, Anna, you struggled too. You did this. And so it instantly is a connection, because we can be like, hey, this is how I felt, but this is what I learned through it. And it allows us to grow together and to learn together. But something I want to ask was, again, with lawyers, I don't want to stereotype, but I'm going to stereotype. If I wanted to find a lawyer, I naturally think I want to find an older lawyer, somebody who's been in it for 30 years, 40 years, because there's a perception that they've had more experience and they're going to be the best versus somebody that's new, fresh out of school. You, I don't know your age, but you appear younger than that lawyer that I'm looking for. Do you ever get any of that with people to where, well, Anna, you're too young, or how long have you been doing this? Really, do you have, valuable information you can share with me?
Oh yeah. There's like comments on every single post, almost like, how old is she? Like it's a really weird thing. And I'm a lot older than I look. So I kind of understand, but I'm in my mid 30s. I've been practicing for, like a decade. So I have been in this field I specialized in this in law school. I worked at the USPTO. So I have a lot of experience that even a lot of senior attorneys don't have in this field. The reason for that is that people don't understand about lawyers is many lawyers switch fields. So there are lawyers that started off doing one thing and then they switched into another field. And so age is a less important indicator than actual experience for a lawyer. There's also lawyers who have worked for many years, 3 times the amount of years that I have worked, but they have done less volume of work. So it's not the best indicator. I will say I'm so against people starting their own law firm and servicing clients right out of law school. I think you have to work at a law firm at least for a couple of years, at least like 3 years, because that first 6 months to a year is where you will learn, depending on the volume of work you're given, but you will learn so much information and you will work on so many cases. You will make so many mistakes. And, I think that first month that I was working, right when I got my bar license and worked that first month, they just hand you things and you have to make your own mistakes and then you have to fix them yourself and deal with it, at least at the firm I was at. So, that experience cannot be replaced. But for me now, I get a lot of pushback on my age, and my, offering though is like, I offer guaranteed services. So I offer guaranteed patents, trademarks, and copyrights, which literally no other law firm in this country offers. And I have 100% success rate. So people can't, at this point in my career, really argue with my results. So that's where I'm at now, right? But I think now I'm kind of more established where I have a lot of answers to the pushback. I think the last couple of years, though, it was a big struggle. But now I just offer this service that it's a guaranteed service. My money is at stake too, because I have to return filing fees and government fees and things too if, I can't get it. So, they can go to any other lawyer that's really old, but if that lawyer can't guarantee what they're doing or they don't have the success rate I have, I usually get picked.
So what does that mean exactly? Guaranteed services. So I'm a business, I come to you. What are the services you're guaranteed? How do you measure that to where there was a return or the KPIs?
So like, let's say you come to me and you want this trademark, right? Or you want a specific task done for a particular trademark. It's a guaranteed service. So, you pay this price and we get you your trademark, or we get you your petition granted, or whatever it is, or your money back.
Gotcha. Okay.
So yeah, it's a measurable result. Like, you'll either get it or you won't.
Got it. Okay.
That's a perfect segue. So with that, let's talk about a little bit about people that are starting businesses and versus established businesses. So, over the 20 plus years, I've probably helped open, I don't know, maybe 1,000, 1,500, somewhere around that area of businesses. Now, the law part, I've never been truly involved in. We've always had partners, or the company handled that on their end. And to be honest, in the last 20 plus years, any of the clientele that I've been a part of, we've only had 3 instances where, say, a company, they got a letter saying there was brand infringement, right? And And then when that happened, I don't say it was easy to sidestep, but it wasn't hard to sidestep, like to make variations from an existing company that's been in business for 2 years. We had to make slight modifications, just enough to bypass
avoid confusion.
Avoid confusion. So it didn't bother their business at all. But they had a good brand guy, right? So I know it could be different, right? If you don't have any guidance and have someone that can walk you through that slight transition and still keep your audience in your engagement, right? Like it's a good thing. We actually use it as a pivot, as it was a good thing, if that makes sense.
Like a rebrand. Yeah.
Yes.
So that's a great point to bring up. So before we get into rebranding, I'm going to go over the 3 main types of IP, just so people who are listening can know some of the words we're throwing out there. Yep. So there's 3 main types of intellectual property: copyrights, patents, trademarks. Copyrights protect anything that's a work of art. So this is books, movies, literature, also architecture, sculptures, certain types of graphics, software can be protected via copyrights. And then patents protect inventions. So patents protect anything that is an improvement upon something else that's invented, or a novel invention. And this can be anything like a tool, a chemical, a compound, a process, a transformational process. Certain types of software, once they're sanitized, quote unquote, once we pull out the processes of the software, can be patented. So patents really cover inventions, things that people are inventing. And then trademarks protect brands. So this is typically, for people listening, this is going to be your name, logo, and slogan. Those are really common brand components. But you can also trademark, a color, a jingle, a smell. You can trademark emotion. You can trademark some types of packaging, things like that. So for the most part, though, trademarks cover brand names, logos, slogans. And when it comes to business mistakes that businesses make, let's start with what trademark mistakes do they make that might cost them money, or they might have to do something different in their business. So yes, if you start a business and you're potentially using something that's the same or confusingly similar to someone else's name, whether it's knowing or not knowing, you're not allowed to do it if they have a trademark for it. And you might get a cease and desist letter, you might get a lawsuit, or you might get some sort of, other notification, a soft cease and desist, so to speak, or you might get some sort of claim filed against you on social media. Sometimes that happens, but you have a couple of options in that case. So you can license the name from the person who's, saying that they own it. This is assuming you've evaluated the claims and they have a legitimate claim. A lot of times they don't. But if you determine that, I need to do something because I don't want to deal with this legal situation, you can license it to them, pay them some sort of fee. You work out an agreement, annual, quarterly, one time, and you continue to do what you're doing. This sometimes is necessary if you have been using the name for a while and you've made a lot of money from it and you don't want to change it, or, if you think it's going to be really expensive to rebrand. So licensing can be a good option. Another option, of course, is just to rebrand. You can do a complete rebrand or a slight rebrand that the other party would be okay with, and work that deal out with them and then rebrand. Now, where rebrands can cost people a lot of money is going to be for expensive domains and inventory. So that's where rebrands can really, you're going to rack up costs for rebrands. I've had a client, they had 100K of inventory, shoe inventory, with their brand, custom emblazed on the shoe, or embossed. I think that's the right word for it. And they, basically had to destroy 100K worth of inventory. And it was, a portion of his life savings. So that was really unfortunate. But, that's one thing, is if you are making a huge investment into your brand, if you're buying a very expensive domain or making a massive inventory, purchase, definitely worth it to at least, make sure you have your own trade, clear it with a trademark attorney, get that trademark on file so no one else can, in the interim, steal it from you. With trademarks, America, at least, we're still a first to use. So the first person to use a brand name is technically the owner. But when you are not the first to file, you now have to go cancel the other person's trademark. And that's really expensive. So your, option now is just 20 times more expensive than it had to be. So you always want to be...
That's why I can ask a clarifying question there. So if I launch my brand first, first to use, that's mine. But if somebody else comes in, then they trademark it because I went first. I have to go cancel. I can cancel them out, but it's just going to cost me a lot of money.
Yep. So you have to, rush file your trademark application. You can either protest or oppose their application, or if it's already registered, you cancel it. So it becomes the actual litigation situation when it could have just been, hey, it's like a couple $1,000s to get this on file and smooth sailing versus, that $30K situation minimum. Some of those cases go into the hundreds of thousands. So let's just caveat this. And this is a really important point for business owners to know that while IP issues, the percentage chance you are going to run into this type of issue is low, like less than, a few percent. But if it happens, IP litigation is exponentially more expensive than any other type of law by an exponential factor. So if you thought lawyers and lawsuits were expensive, IP litigation is 10 to 20 times more expensive than other types of litigation. So if you're going to file a lawsuit against someone, for harassment and it's going to cost you $20K, just to file that complaint for, an IP suit can cost you a lot more than that. And your whole case is going to be a lot more by, like I said, by like a 10x plus factor, exponential factor. So you do not want to get sued for IP infringement, and you want to avoid needing to sue people too.
So if a company is starting, or say they've been in business for 3 years and they just want to cover their butts, right? What kind of investment, what's the average investment a company would invest?
Yeah, I mean, it's really, if you just file your trademark and there's no issues with your trademark, it's literally just a few $1,000s, and that's for an attorney handling the whole thing. So typically people will file their few really important trademarks. Their name is going to be the most important trademark that a company has because it's usually on everything. It's usually your domain. And that's the most expensive thing to change. You can change variations of a logo a little bit easier. You can change slogans a little bit easier, but names are the most expensive, historically thing to rebrand for most brands. So they typically will get their name, logo, and slogan. So you're looking at, a couple thousand per those trademarks, but that kind of covers everything.
Right.
And it's a one and done thing. Your trademark lasts forever once you get it. So that's
and the very few that I've been with, unfortunately, they didn't have to change any domains. More or less, it was just modifying the color palette and dropping a piece of the tagline, as an example.
Yeah. So it was a smaller component of their brand.
It was a smaller component. So
domains these days are just really expensive.
Yes, they are. They are. Absolutely. So a couple grand per trademark.
Yeah, a couple grand per trademark. And, name, logo, slogan. Sometimes people have variations of their logo where they'll have, membership names and subscription name and, other things that can also be protected. But your trademark attorney will kind of evaluate your business and then rank what's priority for you.
And is it okay for any business, no matter how long they've been in business, say they've been in business for 10 years and never had an issue, would you advise for them to go through this process? Yeah.
The reason for that is your business is going to, because you want to think about the exit, your business isn't going to be valued at anything if you don't have your IP registered. So you're not going to be able to sell out and do that. So that's the real problem. So we do a lot of cleanup and we do a lot of chain of title correction with things. We do a lot of last minute emergency filings, expedited filings, because people they've been in business 10 years, never had an issue, but now they want to retire. They want to sell out. They have a buyer, but the buyer's not going to buy a business that's not clean cut. So when we look at the value of IP, just in general, your intellectual property portfolio of any business of any size is between 40 to 60% of the business's value. So if anyone who's starting a business, you should never start a business without the exit plan in mind, first of all, just as a business tip. And when you are going to exit, you are going to need to show that you actually own your brand, you actually own and properly maintained all of your IP registrations, and that you've not had any IP issues and there's not similar brands out there. Because if you have a big business and then somebody there's a trademark filing out there with a similar name, but you've never had an issue with them. They never really contacted you and you want to sell your business. Why would that buyer buy your business? They're buying a liability, because at any given moment, somebody can file that lawsuit against you and take all of the revenue starting from the day of first use or the day of filing, depending on what type of.
So if our audience, let's act like our audience, this is completely new to them. This is the first time they're hearing this. And I go and I want to get my name, my brand trademarked. It's a few $1,000s for that. Is that a one and done to where once you do that today, it's secured for the life? Or is there a length that's secured before you have to do something else, modification?
Yeah, the good thing about trademarks is it's kind of like the big thing is you just get it. And once you get it, it's kind of yours forever. You have to renew your trademark every 5 to 10 years. And it's a few $100s to do that every 5 to 10 years. And you have to show, you can't stop using your trademark during that time. So if you start this business and use your trademark and then you shut down for 5 to 10 years and then try to renew it, that's not really allowed. But the good news is that once you get your trademark and the longer you use it for this and keep renewing it for, let's say you do it for 50 years, the actually more valuable monetarily your brand becomes.
Okay, that makes sense. How about it makes me think of like DBAs, so often a business, they'll create their business and then create a doing business as XYZ.
Yeah, DBAs are pretty worthless in today's day and age, unless you're cashing checks, physical checks. It's the only reason really to have a DBA. DBAs are actually worthless. The name of your LLC doesn't matter. Everyone can name their LLC garbage LLC. It literally will not make a difference for your business. It has nothing to do with your brand.
There you go. So people, don't create a DBA. Don't waste the time.
Yeah.
Whatever size you are, whoever you are.
Yeah. Disclaimer though, that some states and counties make you do a DBA, but in terms of protecting your name and saying, oh, no one else can take it from me or I own it, DBAs have nothing to do with that. The only way to do that is with a trademark.
Okay, where I was going with that was that, if you're saying it's a couple thousand, per trademark kind of a thing, if I create a DBA, then it's a couple thousand more for this. So save the money. Don't even go that route unless your state legislation says you need it. Yeah.
And DBAs are not expensive. They're usually like $10, $25 filing on the state's website. It's usually not something, some attorneys do that stuff, but it's not that necessary.
So it sounds like you're very knowledgeable with all this. There's a lot more services out there. I don't want to name drop, but I'm going to like LegalZoom, .com or these, you can go in and spend $10 and hire a lawyer to do XYZ. Do you have any caution for our listeners for those kind of services, or do you see any value that those can provide?
So I actually really love LegalZoom in terms of the concept of it. I think, first of all, their website's amazing. Their marketing initiatives have just been like a business model to follow, that we should all look at. They did a great job. They infiltrated an industry and they really did well in terms of market capture. They also did really well in finding an extremely difficult, tedious process for people and giving them a very aesthetic, easy to use way to deliver those services. That I implement a lot of those concepts into my business as well. I like to make it so easy for people to work with us. We have really easy forms. Everything is smooth step by step. So I really look up to LegalZoom for doing that. Now, the results LegalZoom gets, legally speaking, in terms of their, what they get people for their businesses and trademarks, their results are really poor, unfortunately. And their pricing is not that inexpensive. When you compare it to an average lawyer versus LegalZoom, it's maybe you're going to save a couple $100, but it's pretty comparable to law prices. So like I said, I can't charge you $10,000 to file a basic trademark. It doesn't work that way. I can definitely charge you $10,000 to file a lawsuit against someone. So, when people think lawyer, they just think expensive, but it's actually not much more expensive than LegalZoom. So it's not $10. It's like between $500 to $1,000, which, a lot of lawyers have prices in that range for the same exact service. So people should really explore their options before they go with those companies. Not saying that there's no value to them. I think that they have provided access to people who don't, can't mentally comprehend going to a lawyer, but there really are a lot of lawyers that provide those same services, and it's not the expense that you think it is.
So LegalZoom was a disruption, right?
Yeah.
And I think there's another disruption going on that a lot of people are jumping on the bandwagon is AI. You hear about AI coming into telehealth, right? And all these things. And I was at a seminar and they actually mentioned the legal field in, precisely saying, what if, they could scan every case in history and do all these searches and give you 100% results, with no errors in this short amount of time?
Well, there is AI legal software that does that. It's the analysis right now that's missing with legal AI. Here's the reality with legal AI at this point in time for searching and data recovery or data gathering. If a lawyer is not using AI, I consider it malpractice at this point. I have to pay, tens of thousands, almost multiple six figures for the softwares that I have at my firm to do these AI searches, but we pay them because it does in 1 second what would take about 50 attorney hours to go through. And, it makes it like a nice report. It's like easy one-click PDF. It has like my law firm logo on it. Like I pay for, I'm paying for the service a lot, but it's giving me good return. If a lawyer is not using these AI softwares, they're, totally billing their client more than they should be is generally how it goes. So the entire typical law firm model is incentivized. When you go to a lawyer and you get all these surprise bills, it's because they're billing you per every minute, every 6 minutes usually, that they're working on your stuff. There's no tangible deliverable. There's no, okay, we've spent 4 hours working on your trademark. Now you're going to get a bill at, $600, $700 an hour for this thing. Of course, people are going to look at that and want to go to LegalZoom, right? But, at the end of the day, if you can find a lawyer that is working with flat fees, it's more predictable. It's pretty common in IP as well to work on flat fees. It's a unique field in that sense. But in general, the lots and lots of lawyers, they bill hourly. They're very incentivized to be inefficient. And that is why I don't think the legal industry is going to adopt AI that quickly. Because why would they adopt something that's going to make them drastically less money? Because I'm telling you, for just say a random trademark search of anything, it would take many attorney hours to come up with the information that I can get in one click with my software. So why would anyone want to give up that money if that's their business model?
Yeah, I've seen big bills like with larger corporations, and I'm like, whoa, okay. No, I agree with you 100%. I think they will slowly adopt it just for that reason. But I think they'll have to adopt it just for that reason, right? Because people like you and other companies, they're going to be more efficient. They're going to come up with more time to spend on more value things for them, right? To provide more value. I look at AI as a way to help do the monotony stuff, the stuff that makes an impact, that say something as simple as writing a blog. It can produce it at 70%, right? But it still needs the human touch, the SEO, all that to really make an impact, or it gets penalized online. So I see that the same in the law industry as well.
I see that too. So I see there being some forced adoption of it. I don't know how they'll survive because most firms, their business model is that hourly billing model. I do only flat fees. So everything, even litigation, everything's flat feed out. So everybody knows what they're paying upfront. I productize the service basically. And that works plus and minus. Some cases you spend a little extra time than you didn't expect. In some cases you spend a little less, and it all evens out at the end of the day. If you're well-versed enough in your field that you can predict those, I've done the same thing so long, I can predict this now, but most law firms will not do that. They make so much money doing the hourly billing model and basically exploiting all their associates, and they bill out their paralegals and admin too, that I don't know that they would survive if they couldn't do the hourly billable model. Because, if a case has a 15% chance of success and it's going to cost you total, if at the start, it's going to cost you $600K to get into that litigation, you're probably not going to get into it, right? But if you just have to give like a 10K retainer, you're probably just going to continue to feed them. So there's a lot of psychological things like that go into it, but AI is going to disrupt the legal industry, but there's still now even there's lawyers that, use AI, and I think they're doing better than, lawyers who aren't using it.
So right now, Anna, there's a big school of thought. Well, it has been, nowadays it's instant gratification. Everybody wants everything now, right? Like here, get successful today by doing this, right? It's not correct, but anyway, that's what everybody's selling. So when it comes to launching a business, an idea, there's a school of thought that says, go to mark fast, go to mark furious, because everything is so fast to market. Have an initial website, get an initial sale, get a proof of concept that your business has legs, right? Before going down too many rabbit holes. So sometimes that rabbit hole could be holding off on, $10,000 worth of trademark, right? They might rather invest $10,000 in pre-sales. So, I mean, what do you think about that whole school of thought?
This is really interesting. So I'm definitely in the camp that you should do what you have to make money as soon as you can, because the reason businesses fail is because they can't make the money. So that is really, really important. However, there's no reason that you need to expose yourself to liability in order to test your concept. You do not need to be giving out your secrets and putting your final, name, your logo, every single component of your brand out there to test proof of concept. You're typically not testing proof concept, at least of a brand. It can definitely be of a product, of a service, like Absolutely. A particular offering, right? But you are not testing proof of concept of your brand name. You do not need to expose every single aspect, every single trademarkable asset out there before you have it protected. That's not necessary to, start making money. So that's one thing, and another thing is you don't need to do all 10 trademarks at once either. Like I said, the most important ones, and your trademark attorney will typically rank for you which ones are absolute priority. This is going to sometimes vary if you have competitors, and maybe you have a competitor in the market with a very similar slogan, and you just want to get that trademark in before anything else. So it's a little bit case by case, but in general, you don't need to invest a ton. You should definitely do the basics though, because it's just like an insurance policy, but you don't need to expose yourself to a lot of liability or expose your, brand or, your copyrighted or content and inventions. You don't have to expose everything right away to test your proof of concept.
No, I totally agree. Depending on what it is, it's like you said, it's the secret sauce. It could be IP related. It could, have a process. It could be,
and when I'll say this about patents. So with trademarking and typically with copywriting, copyright protection actually applies instantaneously. So as soon as you take a photo, make a video, write something, it's that copyright protection. As soon as it's intangible, it's in pen to paper, that becomes protected under copyright law. Now, you don't get the full copyright protection because the law changed recently. You have to go file your registrations and all that, but you get some level of protection for copyrights. For patents on the other, and trademarks, let's talk. Trademarks, you can actually file your trademark. The best time to file a trademark is actually about a year before you publicly launch your brand. But you can file your brand or your trademark for your brand or your intended brand, a lot before you launch. And anytime.
Anna, why 12 months in advance? Why that time frame? Because it takes longer?
So there's actually something called an intent to use trademark, and it's a little bit of a loophole. So if you ever want to know actually what some celebrity or your favorite brand is doing, you can go look up their intent to use trademarks and see what they're going to be launching in a year. So you can file your trademark before you have it's called a specimen, but before you have any evidence of use. So you don't need to expose your website and your products and all of that to file your trademark for those type of trademarks. It's a loophole. So if you have a name that you're in love with, you're going to use it, and you're just not ready to start your business. Maybe you're too busy at that moment, but within the next year or few years, you can't reserve a name forever. But it's a way to reserve a name for at least a few years. You can do it for up to a few years, typically a year. It's going to take a year for that trademark to process. And then on the back end, you can file that evidence of use, show them that you're using it, and then you get your trademark. So it is a way to limit your liability, basically. And that's why all celebrities and big companies do it that way. But it's like I said, it's just a loophole. And so that's the best, safest and cheapest, cleanest way to get a trademark. This is really important if you have a, difficult name to get, things like that. You want to go that pathway. Now with trademarks, though, like I'm talking about, the earlier you get that filing in, the better. So ideally, the best time, a few years before, at least a year before you launch. Anytime, before you launch is great. And then if you haven't gotten a trademark, getting it in today is better than in a year. That's kind of how it works, because the value of your trademark registration increases too, the longer you have it registered. So just thinking about the exit in mind, that's really good. So trademarks, the earlier the better. With patents, not the case at all. You have to be extremely careful if you have something that is patentable subject matter and you want to protect it with patents, or you want to just get a patent on it and license it or sell the patent, whatever you're trying to do. Your patent, you can actually bar yourself from obtaining a patent if you expose your invention too early. So if you publicly disclose your invention and then you don't file a patent on it within 1 year, you get a 1-year grace period. But if you do not file that patent application in that time period, you cannot obtain patent protection for it. You have barred yourself.
Wow.
So the timing of patents, not just publicly disclosing on social media or at a conference or something, I'm talking like you better have protected that invention with NDAs, proper contracts, all of that, kept it limited so that you can prove to the USPTO that you have not publicly disclosed this and you're still allowed to get patent protection. I mean, it's really tricky, the timing of patents. And it's really unfortunate when people bar themselves because they posted about it on social and they can't get protection now. So, or they told their spouse and they didn't have an NDA with their spouse about it. So that type of thing happens. And, they're very strict. The law changed recently, and America, for patents, different than trademarks, we are a first to file country, strict first to file. So if somebody else files that patent before you can, or you barred yourself from getting that patent protection, you're out of luck. There's really no fighting it out. Like with trademarks, you have the option to fight things out. Patents, pretty much no. So, of course, I'm disclaiming this, that there's always exceptions here and there legally, but for the most part, when you have a patent, you really cannot just go out there and start blabbing about it and start saying, oh, I got to sell this to make money. If you actually have something that's patentable subject matter and it has value, there's market value to it, you should be careful with your timing.
And that first year is a provisional.
You can't, you also can't just go on the last day of your deadline either, because patents take several weeks, sometimes months to draft.
Yeah. Yeah. So
that's good info to know right there. I didn't know any of that.
Yeah.
For a year is provisional, correct?
No,
Anna?
but you can file within the grace period, you can file a provisional. But I'm talking about public disclosure. So if you just disclose it, I'm talking like on social media, in a conference, in an article, if you publicly disclose your invention prior to doing any filing on it, or even if you discuss it with people, or, people figure out things about it and, you don't have NDAs with them to prove that you were actually protecting it, or just doing a market research study or something like that. You don't have those contracts in place. You have now publicly disclosed your invention prior to having any sort of provisional, non-provisional, whatnot application on it. So you get that 1 year grace period, and then you can file a provisional, which is like a placeholder patent for 1 year. Then you can convert it to the real patent application. Yeah.
After that year. So I always wondered, now I'm a little ignorant to this subject, but the provisional patent for that year, companies will launch in that stage. Is there any scenarios where that provisional doesn't go through or needs to get modified before it becomes
that
like a real?
That provisional will not go through. It is not an patent application that's going to be looked at by the USPTO. It is solely a placeholder. It is buying you time. Yeah.
Got you.
It is never going to get looked at. The value of the provisional is, number one, huge marketing value of saying patent pending. They've done studies on this, that when people put patent pending on something, the sales, it's proven very effective for marketing purposes. Another thing is, you now can go license and sell that, whatever it is, to someone else and let them deal with the, non-provisional and have all the expenses of the non-provisional. Or a third case scenario that's very, very, very common is people just simply don't have their absolute final product ready. And they, that's why they do their provisional, which, you can tweak a little bit. You can't really add new subject matter. It gets technical. Patents are really technical, but if you just need a little more time for figuring out final touches of it, or if you need more time to get investment money, things like that, that patent pending, that provisional patent application, the placeholder application is more informal. And it is not as expensive or intensive as the real patent, the non-provisional application. Non-provisional, will be examined. And there's a note about will that not go through? Will it get refused? So it will probably get an initial refusal. And you actually, for patents, want that. Because if your patent goes through without any sort of refusal, it means you have too narrow of protection. You want to get the most protection you can. So you want your attorney to fight it out a little bit with the examiner and get you the most that they can get. Because if you're just asking for, 10% when you could have gotten 30%, you just lost out 20%. And that is a gap in the market for someone else to get.
So I know patent pending, provisional, there's always a caveat, right? I know a lot of organizations that's had trouble between that provisional to that final patent. It's been a bumpy road per se. They had to make changes, and then we had to back up and make modifications on our end. Say we've been marketing for a year. Is that usual or is that unusual?
It really just depends on where the product is in development when they are filing that. It depends on are they keeping the same attorney through the whole process? That's ideal. It's expensive to switch attorneys. It's, are they changing significantly the actual product to the level that now you're dealing with, have I publicly disclosed too much to now get a new patent on my modified invention? So there's so much that goes into that.
Oh, yeah, there is. There is a lot. Yeah. So that's why I love being on the marketing side.
I love being on the law side. But, the most important thing is with patents, like I said, is that, you do not want to bar, this is a mistake, right? We're talking about some legal mistakes. So one of the big ones I see with, smaller companies, they have a small R&D team or individual inventors is they publicly disclose and they bar themselves from getting, the patent on it. So the reasoning behind that is the USPTO does not want people to retroactively protect their inventions. They want people so they don't allow it. They want people to be protecting their inventions per the correct timeline of how business should be.
That makes sense. I think, Anna, we're coming up against time here. I have one last question for you. You mentioned earlier, you said any person that starts a business but doesn't think of the end in sight, their exit strategy, that's kind of like a requirement. So what is yours? When you started your firm, what is your end in sight with your exit strategy with what you're doing?
My exit strategy has now changed from kind of what I thought it would be. But my exit strategy right now for my firm is going to be being able to deliver legal services in a productized format with actual deliverables and being able to scale that. And potentially, I'm not a tech person, but, potentially getting, developing some app or developing some sort of technology that would be able to productize these services. I'm a scientist too, I have a science background. So everything I do, it's a formula, it's a checklist. That's why I have the success rate I have actually is because I don't skip steps. There's really no shortcuts in life. And there's no shortcuts in life except for the people who don't really need them. And, once you're at the top, there's a lot of shortcuts for you, but the people who want shortcuts or take shortcuts, there's no shortcut for them, really. That's just how life works. But if you skip steps and processes, it doesn't work out well. I have been doing this, so long. I really do very limited scope of services that everything I do, I have such an intensive, system and process for that just delivers and just works. And I want to apply technology to it. That's kind of where I see my next step.
That's awesome. That's awesome. Good for you. I think you're definitely paving the way, and I think you're taking names, kicking butt and taking names as you're doing it too. So,
and she travels quite a lot. I noticed that.
Yeah, I love to travel. I know because I live between like Miami and, up north. So, just seasonally, but then I travel a lot too. So, yeah.
That's awesome. Well, and what you're doing, look at decades ago, virtual meetings, doing what we're doing right now and having a client where you could have a lawyer virtually, it was just unheard of. And so, technology and all this is changing the game so much to where you don't have to be localized somewhere, to be able to have clients. I know you're nationwide, and just seeing some of your social stuff, you've gotten, I don't know the right words, but you're able to do things in different states now. And so expanding your reach so much further. And so, there's a lot more opportunity.
For all service providers now, you don't have to go down and pick the marketing firm next door, the law firm next door who maybe doesn't resonate with you, or they don't specialize in what you really need them to. So it just has opened up everything for businesses now that 100%. You can, provide services digitally.
Yeah, and it's interesting how you mentioned that, because we, like, people that come our way, when a client comes our way or a prospect, they may type in, marketing agency or branding agency. They still type the Charlotte, North Carolina, or Franklin, Tennessee, or Sacramento, California, whatever it is. But we can position our brand to where we show up nationwide if we want to. So even though we can be centered here, we still show up for somebody searching over here. And so, there's 1,000 ways to skin a cat, and it's just interesting all the opportunity we have now.
Yeah, it's so funny. So I used to be licensed only in Illinois. Now I'm licensed in several states, and I switched my branding to DC. And I used to get so many questions like, hey, I'm in California, wherever. Can you help me? And so now I don't get it because I'm in DC. So right. I think that's funny that, people still are thinking local, but, when it comes to getting service or delivering service now, I think we're, global. You could be global now easily.
100%. And you can build your real estate online to where I can build a beautiful website, social media presence, and everything to where it looks like I have a team of 1,000 people behind me, take pictures, big office, all this stuff. But at the end of the day, it could just be one little person over here in a small office, that's just portraying. And so what we do online, perception truly is reality, because it's not always the case that it is reality.
It's so important. Yeah. Perception is so important. And brand positioning, or how you need it to be for your market, is so important. That's your guys' awesome. Specialty.
And one thing, Anna has extensive experience with social media, intellectual property, infringement issues, which is huge. You work with Meta, TikTok, Twitter with most of your clients.
I have a lot of contacts at the platforms, and, I'm just well versed in how the terms of service and things are too.
So, hey, I'm seeing any company size, big, small, startup, 10 years, 20 years, call in a law. It's like...
Yeah, we work with all companies. We only do one thing, but I promise we'll do it better than anyone else.
But any company could utilize this. I think any of your specialties, I think any company in today's market will deal with at least one of your specialties for sure.
Oh yeah.
I think what we're going to have to do, we're going to have a part 2, get Anna back on, because I feel like we only scratched the surface here.
I know there were so many legal mistakes. There's so much I want to get into.
But Anna, this was so good. This was so valuable. I have some questions here that we didn't even get to. So maybe down the road we can have you on again and just kind of continue this, because our audience needs this kind of stuff. This is one of those topics where they just don't know what they don't know, and it's extremely valuable for the lifeblood of their business. So for the people that are listening, how can they follow you? Where's the best place you want to send them so that they can keep up with you?
Yeah, I think Instagram and LinkedIn, I definitely post the most on, or they can just contact me, through my website, just ANALaw.com, ANALAW.com.
Love it. Perfect. Simple.
Perfect.
ANALaw.com.
ANALaw.com. Well, Anna, thank you so much for joining us today and everything you shared. It was such a pleasure having you on with us.
Yes, I had so much fun.
I know you dropped so many valuable nuggets for whoever's listening, so I appreciate it so much, Anna.
Yeah, thanks for having me on, guys.
All right.
All right. We'll talk to you later.
Talk soon.
Bye, guys.
Thanks for listening and joining us on the Love Your Brand podcast. Stay tuned for the next episode, and remember, share the love.